see here.
Today we'll be discussing job performance and discipline, specifically discipline of employees of protected classes. We'll also discuss the difference between misconduct and poor performance. And we'll also discuss common mistakes that happen in the employment setting that can turn into litigation. So first off, there's 4 criteria that govern use of disciplinary procedures. When determining whether or not to take disciplinary action and which action to take, these 4 criteria should be in consideration. First, the severity of the offense. This helps to determine whether or not disciplinary action is needed and at what level. I think that we can all agree that some offenses are so serious that they might merit termination at first instance for the first offense. Maybe think to yourself momentarily what types of disciplinary infractions these might be. But I think initially things of serious drug and alcohol nature, gross safety violations, especially when we have a drug and alcohol offense coupled with perhaps a safety violation, gross insubordination, theft, fighting. We'll also consider an employee's past record. A long record of good service begs consideration when minor disciplinary infractions occur. A short service record punctuated by frequent disciplinary problems may merit more severe immediate discipline. We also consider employees' length of service. Long service is often viewed as a mitigating factor in determining disciplinary actions. This is particularly prevalent in work environments where seniority is heavily weighed in other employment decisions. And lastly, we consider past actions in similar incidents. Most companies establish some sort of a going rate for similar disciplinary infractions. Going significantly, above or below that going rate that you have established at your place for any given infraction may appear to be discrimination or favoritism. So we're always watchful and mindful of that. Now, you may have heard me compare this to the hot stove rule before, but one way to look at the employee discipline is to consider the hot stove rule. From an employee's perspective, being disciplined, it should be similar to what happens really when a kid touches a hot stove. If they decide to touch the stove, the reaction by you is immediate, impersonal, and consistent. Immediate in that there's no delay between the act and the consequences. Impersonal in that it does not matter who you are, there are no favorites, and there's no discrimination. Whoever touches the hot stove is going to get burnt. And it's consistent in that the stove gives an equal burn to anyone who touches it. Those who touch it more often or for a longer period of time will receive worse burns. Now, the difficulty comes in when disciplining and using the hot stove rule, if you will, for protected classes. When disciplining members of a protected class, there's always the potential for an employment claim. It is not uncommon for the employee being disciplined to assert that they were somehow targeted for disciplinary action based on their protected status. Presumptively, they will always recall the stray remarks made to them or about them, that even that they heard through the grapevine, and link those up in some way to the disciplinary action or the termination. So first, the most basic but helpful advice I can give for you to avoid this trap is to document what is happening with your employees. You may not expect them to allege unlawfulness against you or your company, because it's always good until it's not. But when they do, you want there to be documentation that tells a story, that proves a story, that particularly proves the story you have depicted of them, that is the basis of the employment action. That story from your perspective is going to be not discriminatory and going to be legal and legitimate. But without that story and that in real-time documentation, you'll be lacking that proof. Second, you'll investigate any potential for adverse impact. So when I speak of adverse impact, I'm speaking of any employer practices, hiring, promotion, layoff, discipline, terminations, that work to disadvantage protected groups. Look for any patterns in your recent disciplinary actions that might indicate that protected group is being targeted at a higher rate than other groups. Make sure your employment decisions are based on job-related factors only. And finally, make sure there's no public policy exceptions to consider. These possibilities are much too numerous for me to list here, and I won't bore you with them, but here's some guidelines to think about. Review if the employee has a record of any recent internal claims, complaints, or requests, as they might be potentially considered an exercise of protected rights under the law. So these claims, complaints, requests could be harassment-based, unfair treatment-based, or anything generally. Even if these claims, complaints, or requests have nothing to do with the disciplinary action at hand, they can be used by that employee to paint a general picture of discrimination or retaliation in the future. So that is why we want to make sure we see a full picture with an employee, even if the tangible employment action against them is not directly related to some complaint or claim or request that they previously made. We see that in the aggregate, it can perhaps look a certain way. So let's do a quick reminder here as to what some protected classes are. This is more of an advanced webinar. We're moving quickly, and I kind of am acting on the assumption that you know the fundamentals. We have other webinars established that go through the fundamentals. So this one's more in an understanding that you've watched those others. So I'm not here to talk about protected classes and categories. Really, I'm just going to quickly remind you that specifically in Montana, for those listening in Montana, age includes any age. Now, I'm done talking about Montana. Disability includes physical or mental disability. That's across the board. Sex includes pregnancy, maternity, sexual harassment, gender identity, including transgender status, and sexual orientation. Those are new additions to the law, so note that. Protected status, will vary by jurisdiction. So many states and counties and city governments have passed laws that add additional protected classes to the list on this slide, but those are some fundamental ones that you should be aware of. Let's go through a case example and put our knowledge to the test to see how we would be able to conclude. In this case example, the plaintiff, who is an employee of your company, is Cameroonian and Black. He is terminated from his position, and let's say it was a few years ago, back on July 11th of 2014, and on September 2nd of the same year, he filed a charge of discrimination and retaliation. I take this case example from a case that came out of Idaho and is actually a real case. Plaintiff alleged that he suffered 2 discriminatory incidents during his tenure. The first occurred at a 2013 Christmas event that was at the company headquarters. And at that event, a salesperson employed by the company sort of quizzed the plaintiff about his nationality of origin and asked the plaintiff some American citizenship test questions, sort of from the salesman's perspective in a joking manner, and included some questions in there about the Civil War and former American presidents, and all this happened in the presence of executives of the company. This interaction lasted about 3 to 4 minutes. On a separate and subsequent occasion, the plaintiff, who was then an employee of the company, spoke with that same salesman for several minutes, along with some other employee, where he was asked questions about nationality and a green card. A little context to this, there were no facts that indicated that necessarily the salesman was really attacking him, but more or less sort of saying, how difficult is it to get a green card? I have a friend that needs one, and these were just sort of matters of conversation. Now, during the same time period of the racial discussions, let's say hypothetically that this employee was not really complying with your company policy, whether he was underperforming or he was having problems with absenteeism or just general behavior issues. But let's say that you were getting ready to probably fire him at some point anyway, or nonetheless, have a stern talking to with him. And let's say maybe you even already restricted a promotion from him or some sort of bonus compensation. Imagine from a third-party perspective, like say the EEOC or a court or a plaintiff's counsel, how this is going to appear. We know how this employee really works and why we may or may not want continued employment with him. We know it has nothing to do with his race or national origin. That's our perspective. But based off these facts, we don't have any documentation of any of the things that we're thinking in our mind that are giving rise to why we would want to let him go. And then he all of a sudden has these allegations against us. From the employer perspective, it's easy to think, well, obviously, his termination or whatever is attributable to his behavior, or his, underperformance or absenteeism or whatever it is. But it's not until the employee is upset, that he brings things up that show indications of potential discrimination. People get upset when they don't get the promotion they want, when their manager tells them, to do something different or tells them to be on time, or when they get terminated, right? So often the decision maker at the company, who's maybe actually making the ultimate decision on regarding the subject of the employee, that person doesn't even know about the things that employee ends up claiming against the company. But that's not what the employee is going to claim. The employee is going to say that basically the ultimate decision maker, whether that was HR or the general manager of the company or whomever, was a culprit, or at minimum had a listening ear to the person that was harassing them or having some sort of discriminatory behavior against them. So of course, in our minds, we think, well, there's no relation there, but the plaintiff employee can ultimately depict a different picture. I'm not going to completely get into the legal analysis of all this because that's unnecessary, but I do want, for just context, I think it's really helpful for business people to understand, what to be watchful of, and to kind of know in a very general sense how claims go through court, because then you have a watchful eye and a discerning ear in your employment setting, and you know when there are triggers, and when to, for instance, contact me. So the court analyzes claims like this of Title VII claims through a burden shifting framework. Basically, a plaintiff has to establish what's called a prima facie case, and it's based on circumstantial evidence showing that, one, he's a member of a protected class. And our hypothetical here, the plaintiff is Cameroonian, which is his national origin in Africa, and he's Black, the color of his skin. Second, on that prima facie case, he would have to show that he was qualified for his position and that he's performing his position satisfactorily. Now, this is where there's always argument. The employer says, well, that's the problem. He wasn't performing adequately or satisfactorily, but then the employer has little to no evidence to, bolster that claim. The third prong is that he must have experienced an adverse employment action. So, this often, the trigger point is when we, deny the employee something that they should have received or allegedly should have received, or ultimately we just terminated them. And then fourth, the plaintiff would have to establish that similarly situated individuals that are outside of his protected class, so say, he's a millwright, for instance, or, we'll just go with millwright. He would have to say that other millwrights that are outside of his protected class are treated more favorably. Now, if he couldn't show that, then he would have to show other circumstances surrounding the adverse employment action that gives rise to an inference of discrimination. So in this hypothetical, it could be the circumstances surrounding the comments that salesman made to the employee in front of executives, and then on a separate occasion, the comments that were made to him just independently. So those would be circumstances surrounding and to provide an inference of discrimination. Or the person could just show that, other people outside of my class that have my same job or a similar job are treated more favorably. They always get those bonuses, but I didn't. So there's two ways of going about that. Now, if the plaintiff establishes a prima facie case, the burden of production then shifts to the employer to articulate some legitimate non-discriminatory reason for the challenged action. Inevitably, this is when we come and say, oh, the person was a terrible employee. et cetera, et cetera, et cetera. All the things that we want to, show and say. We were going to fire him way before that, but we kept giving him chances. And the first thing that we're going to ask them is, okay, where's that documentation? Oh, there's no documentation. That's going to be a problem. As a general matter, the plaintiff in an employment discrimination need only produce, really little evidence in order to overcome an employer's motion for summary judgment. So summary judgment's basically, in layman's terms, a way of getting a case to just stop, be dismissed, and not go to trial, which is what we'd want. If we end up having to get sued, we don't want to go to trial. We want the court to decide it on summary judgment, cost efficiency, and we also don't want a sympathetic jury giving somebody $4 million for something that maybe the court would say is worth, back wages of 6 months. So essentially, the employer needs to show proof that the discipline or termination was unrelated to the fact that the employee was a protected class, and that the discriminatory acts that were alleged are not at all attributable to the discipline or termination. The ultimate decision maker, we need to show that the ultimate decision maker did not regard the bias of the person that actually was acting in a discriminatory fashion against that employee. So in our hypothetical, we'd have to show that, the HR director that officially terminated the employee, who's Cameroonian and Black, had no bias against him. There's no evidence that that person did. But then the other question is, did the HR director that made the ultimate decision, along with this person's manager, did those two people have a listening ear to that salesman that was sort of giving rise to some sort of, I don't know if we want to actually say it was discriminatory comments, but definitely racial based interests, and I think that, there were some other things that went along with that, which I'm not going to get into, and I left out our hypothetical for simplicity. But the question is going to say, did the HR director and manager have a discrimination or bias issue with that person, or did they have a listening ear to that person that did have the issue with that protected class? And so, is the salesman and his manager, friends or close colleagues, or otherwise talking about him, or is that salesman putting a bad light unfairly to him? So the ultimate question is, how do we show that the alleged discriminatory acts were not at all attributable to the discipline or termination? We really show that by progressive discipline in many fashions. The other fashion would probably be documentation, just legitimate in real-time documentation, even better if that employee signed off and acknowledging that he was, written up or given verbal warnings. But that's part of progressive discipline, is that we show a history of documentation with this person, and it's not nitpicking everything the person does. Granted, we all make mistakes and we are all imperfect. The standard should never be perfection, but those things that, required you to give some additional thoughts and, correction to, you really should document on your own, and, even have that person sign off that you guys talked about the subject matter. A common mistake that leads to litigation is when an employment decision is made just because you can make it. So for those of you that are in at-will states, so not talking to my Montana people, but we say, oh, well, it's Word, we throw a lot of different terms around that are used for at-will, but we're a right to work or an at-will state. We can do what we want when we want. Well, sort of, but the problem is going to be that when you do that with no support and legitimacy of proof to what your decision is, how are you going to defend yourself against any allegations against your company? So progressive discipline, and typical steps include a verbal warning, written warning, final warning with suspension and termination. These do not need to be specifically followed in all 4 steps, but just think of this kind of as a general sense. We've talked about a series of steps that typically are employed as part of a progressive discipline process. And we talked about criteria for considering, infractions within the workplace. And so it may, we may have a couple different infractions and we chose not to actually terminate because of based on, we evaluated it based on that criteria we earlier talked about. But we nonetheless have, a track of warnings. The first 3 steps are really designed to encourage the employee to correct their behavior and improve their performance. And the outcome of these disciplinary steps should be improved behavior or performance on the part of the employee. And termination is the outcome if the progressive discipline steps are unsuccessful in correcting the behavior. The most critical step in successfully managing problematic employee behaviors is the manager's discussion of the behaviors with the employee. Now, to be effective, the discussion must address the inadequate performance without destroying the underlying relationship. That's tricky, and to be honest, it's a rarity that I see managers that are really good at this. And the reason is because we promoted our managers usually because of either just seniority or they just happen to be really good at their job. But, rarely think about it. When was the last time you promoted someone to be a manager because they're really good with people? That, in my experience, happens less often than the promotion of someone just because they've been there for a long time or because they're really good at their particular job and skill set that's needed for the performance of their job. So we're putting in the hands of people that often are not that great with other people or certainly are not specifically trained in human relations to provide this discussion and direction. Your managers should keep in mind that a primary purpose of meeting with that troubled employee is to reach an agreement that a problem exists. So you want to hold a meeting and do it privately, not where the person's going to be embarrassed. The manager should begin by stating the purpose of the meeting, what the purpose of the meeting is, and providing reassurance that the intent is to gain an understanding from the employee's perspective. We already know what our perspective is. And we don't want to blame the employee or establish guilt or innocence here. The manager, may want to state up front that, he'll give the employee a chance to add any information that's relevant to find resolution to the situation. And then the manager, should specifically describe the employee's disruptive behaviors. And this is for all in an attempt to get the employee to agree that a problem exists. When the employee and the manager, are in effort trying to become agreeable here, and you're going to have to look at, alternative ways to address the problem and behaviors. Lastly, the manager and employee should agree on a concrete solution to the problem. This step requires the employee's commitment to make changes to his or her behavior and not the simply, I'll try to do better. We want something concrete, but we can't get a confirmation that is concrete unless we can get them to agree that there's a problem. So you see, how this trails onward. And the manager should emphasize the developmental nature of the meeting and then close with encouragement. Often, because managers are not always the best at this and they're not well trained in this, we include the HR director or perhaps the office manager / HR person, but someone that has a little bit more sensitivity to human relations. We can include the manager in that meeting as well, of course. But if you've got a manager that just is not your guy or your gal to be doing that, then make sure you have someone leading that meeting that is the person. Being mindful of time, we will continue forward, but I generally like to keep these around 30 minutes, no more than 40. So we have about 10 minutes left. So we'll go ahead and pick up here. When this meeting, we're still talking about the meeting that we're having with the employee, being confronted by anyone is difficult, as an adult. So again, we need our managers to understand the need to be prepared for a variety of responses when speaking to the employee about disruptive behaviors. And common employee responses are, I'm sure we've all experienced them with other people, anger or just intimidation, aggression, some sort of emotional reaction that's either of despair or just anger, complaining, silence, and then most prevalent, blaming and burden shifting. So when we're prepared for that, and we already know that initially it's going to be a little bit rough, and that's why we have to go into it with a certain presence, it really does help that dialogue. Again, why do we care about that? Because we want a solution to the problem. And even if we know, or we think we know, that that person's not going to change, we want to have an excellent documentation of an excellent job that we did in trying to resolve the matter with that person. Because when we ultimately have to terminate them, we will be able to be well grounded in that and be able to be in a great place to defend ourselves because we did it right the first time. Emotionally charged situations, I think, use common sense. So let's touch on misconduct versus poor performance. Let's make a distinction here between misconduct and poor performance. Misconduct is breaking workplace rules that govern employee conduct. Most employee handbooks contain a list of items that are considered misconduct. Some examples are fighting, theft, insubordination, threats, harassment, substance abuse, failing to call in for an absence, falsifying time cards, etc. Poor performance is the result of an employee either being unable or unwilling to perform the job at an acceptable level. There can be several reasons behind poor performance, including the lack of knowledge, skills, and ability, not understanding expectations, unclear goals, or just a lack of desire. This, I will note, and I say it in a very general sense because each state's laws are a little bit different regarding unemployment compensation, but this also matters with regards to unemployment compensation. Sometimes employers are like, hey, I terminated this person for cause, and why are they, granted unemployment benefits? We want to appeal that. Well, depending on the state and the exact wording and everything, the person could still be getting unemployment benefits even if you fired them for cause because they lack, the skills to perform their job or adequate knowledge or whatever. They could still be getting that even though you did fire them for cause. The cause was poor performance. Whereas if it was a termination for misconduct, and again, each state kind of differs on their definition and wording and terminology of that. But if it was, termination for something like that, then the person would be denied unemployment benefits. So this doesn't just apply, or this is not just applicable and important for employment law claims, it's also regarding unemployment benefits. But nonetheless, in cases of poor performance, progressive discipline approaches are generally advisable. And in cases of misconduct, excuse me, I was backwards on that. I'll say that it's advisable in both, but in cases of misconduct, it may be a little less needed, just because, fighting or theft or something like that is a little bit more showable, to the evidence record versus saying poor performance. It's very illusory, and you're going to need to show some documentation as to exactly what you mean by that. Otherwise, when you have a claim of discrimination or something else against you, it kind of looks like you're just making things up. So how many warnings? Well, it depends on the following. I would say that it's critical to get employee signatures. I kind of mentioned that just a moment ago, that we do document things. I understand we don't need to make a big deal out of everything, so sometimes we just might make a personal note in the file. But on other matters, that we're really trying to deal with someone in a certain way, and it's going to be best to document what you guys are going to talk about, what you said to them, and then get their signature. Now, a lot of people refuse to sign, and so you say, this is not a signature that you even agree. It's a signature that acknowledges we had this discussion. And if they refuse to sign that, then you get some, preferably 2 other people of management that witnessed the evaluation of the employee or discipline of the employee take place and sign off on it and attest to the fact that it happened, and then document that the employee refused to sign it, even have the employee write on there, I refuse to sign this, which is great because it's basically like them signing it anyway. But basically, we're just wanting to show that, we're not making this documentation up. We did have these issues with this person, and we have documentation to support it. And even better, we have their attestation to it, whether that's their signature or them writing on there, I don't want to sign it. The most common mistakes, really in summary, employment decisions that are made without a record. No documentation, no progressive discipline. If you aren't going to do progressive discipline, then we should have documentation. And if you don't have any documentation on the person, then you want to have some evidence of progressive discipline. And in an ideal world, you have both. Another common mistake, failure to document consistently. So we kind of have like, 25% of what we really need, and then it kind of just seems very fractured, and we have to piecemeal everything together. The problem, employee who has good evaluations, I always do have to momentarily laugh when someone is telling me about the terrible employee that they have and how they need to get rid of them, but we have some legal issues, and then I look at their most recent performance evaluation that just took place a month ago, and they were a 5 out of 5 employee. It just doesn't make sense. Another one is making exceptions for one employee but not another. Now, we talked about the 4 criteria that we use to decide how we're going to discipline an employee. So there are going to be some variations, and we take into account repeated instances of infractions versus maybe this is your first or second time. We take into consideration your seniority and your longevity there, and the nature of the issue, et cetera, et cetera. So, there will be some variation, but we don't want those big exceptions happening for some but not others, especially those within the same protected class. So we may make certain exceptions for our more senior level people, but not for the more junior level people. But we're not going to be sporadic, and sometimes the junior people get all of this and none of that, and sometimes the senior people get all of this and none of that. There should be some consistency. We want to follow up when we say we're going to do something, and we also want to follow up when company procedures and policies are allegedly not being met, or performance is not being met. And even if it's a simple, casual conversation with the person, document that, because that's going to be helpful for us. And don't use vague language about consequences, and don't use your opinion, just use facts. If you have any questions, of course, don't hesitate to reach out to me or Letitia, our HR director. Both of us are more than willing to help. These webinars are recorded for your edification, so I'm unable to answer any questions sent in chat, but definitely reach out to me, email, and I will be happy to help. See you next time.
Interesting.